Hello? I can't hear y'all. We have a felony plea, Your Honor.
Thank you. Motion's been tendered, sir. Come around. What I need to do?
Somebody needs to turn that down.
Yeah, I'm here, sir.
The volume's up.
I'm right here.
Mr. Howard, when we want you, we'll ask for you, buddy.
Oh, yes, sir. Sorry.
Okay.
On the docket.
Hello?
Yes, sir.
Hello?
Yes, sir.
Mr. Howard, the next time I hear your voice, it should be in response to me calling your name. Other than that, you keep quiet. A motion's been tendered, sir, that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23
Yeah, that is correct.
CR 0056? Is your judgment impaired today in any way? Have you discussed this matter with your attorney and are you satisfied with his advice? You had an opportunity to review the evidence against you. You feel like you're fully informed about your case. You have to say something. It's a
Yes.
voice activated.
Yeah, yes, that is correct.
Okay. You understand that you do not have to enter a guilty plea today.
Right.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand those rights.
Right.
I'm going to go over them, and at the end, I'm going to ask you to verify that. You have the right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering guilty plea today, you give up all those rights. Is that true?
Yes, I
I
understand.
may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll have a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. If y'all will step to the left a little bit, and Mr. Stockton, come around. Listen very carefully, sir, as to what they say the Commonwealth's offer is.
Your Honor, Mr. Denton will plead guilty to possession of controlled substance first degree, receive a sentence of 3 years, probated for 5, supervised. He'll be assessed by the commission, follow all recommendations. All evidence in this case will be destroyed and he'll maintain gainful employment.
Is that what you agreed to, sir?
Yes, sir.
Okay. Is that your signature on the document?
Yes.
I will accept the plea. Order a pre-sentence investigation report to be done by probation and parole, and have your sentencing on January the 18th. So you don't need to meet with the probation and parole officers over there. Give the information to them, okay?
Okay. Thanks, sir.
Yeah, thank you. Terry Jackson. It says dismiss or divert. What does that mean? Terry Jackson.
Yeah, that's to be dismissed, diverted. We'll tender an order.
Okay.
It's not,
No, I don't think about that one.
not this. This is the one where I think, I apologize, Your Honor. This is the one where he has a pending case, so I'm not gonna, it'll just expire, I guess. But if there's still time, I may come back and file a motion to revoke, but I've got to look at it.
Run another case consecutive with it, I believe.
Yeah.
Let me have the file. I'm not following.
He was on for a pretrial diversion in this case. And
Yes.
what happened later was he entered a subsequent plea, and I guess I must have overlooked the diversion. It's consecutive to this. And as long as he's doing okay, I'll let this one expire. But I need to go back and look at the two cases.
Okay, well, let's just pass it to the next rule day,
That's fine.
January 18th. Dustin Key for arraignment. Are you Dustin Key?
Yes, sir.
What's your year of birth?
11/15/1997.
You born in 1997? What's the last four digits of your social security number?
9115.
You have the right to remain silent. You're represented by counsel. You're here today for the purpose of arraignment. That means that we're just going to read the charges against you, okay? A grand jury of Monroe County's returned an indictment charges of alcohol intoxication, disorderly conduct, wanton endangerment in the first degree. 2 counts. Assault in 4th degree. You understand those charges? You understand what they are? I'm not asking where you did or not. Do you understand what the charges are?
Yes, sir.
Okay. Mr. Bell, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir, Judge. Judge, could I address one thing quickly with the court?
Yeah.
Mr. Keys has a bond that forbids him from being
Let
around.
me set the dates here and then we'll talk about the bond.
Sure.
I want you to do a negotiation date of January 12th at 9 a.m. And the next court date is January 18th. Now you wish to address the bond. Go ahead.
Only thing I'm asking, Judge, is if you could amend the bond to allow him to have no unlawful contact with the victim in the case. She has requested that. We did
Is
it.
she here?
No, sir.
She was requesting that on the tape, Judge, when the officers on the body cam the day he threw her down to the ground twice because she's in the nursing school and didn't have anybody to take care of her kids. So I think if that's something she wants to agree to, talks to us, I'll make it.
I'll do an agreed order, but I just am not in the habit of changing the bond when a victim is not present and the alleged perpetrator says that she says this or that. You know what I'm saying?
Thank you.
So I'll consider that. Ashley Lewis. Ashley Lewis.
John.
Commonwealth versus Ashley Lewis, 23 CR 0061. You are Ashley Lewis. Let her behind there and you get on this side of it, okay? Here for a pretrial conference. Miss Lewis, you born in 1987.
Yes, sir.
That's 4 digits, social security number 1474.
Yes, Your Honor.
Okay, what does the Commonwealth have to say in this case?
Your Honor, I just received, I don't know, about 20 pages of documentation from the Barron River Drug Task Force. And if we don't resolve this case, I'll have to file 404B. So I would ask for one more pretrial negotiation. If that doesn't do any good, we'll set trial next month.
What are the charges? There are multiple charges here.
She's charged with having
Move over here and let me.
trafficking. She had a pound of meth in a backpack in front of her feet. There's search warrants and stuff that was executed in Barron County that has other evidence that was found. So that's where we are.
Judge, there's about 30 pages, about 26 or 30 pages. We've not been through that, all the way through that yet, Judge. So if we can have.
January the 12th for a negotiation date. The next court appearance, January 18th.
Thank you.
Yes, Your Honor.
Robert McClendon.
He's downstairs.
Okay. Jacob Newberry. Are you Jacob Newberry?
Yes, Your Honor.
You were born in 1980.
Yes, Your Honor.
Last four digits, social security number 2356.
Yes.
You're on 22 CR 0069 for arraignment. You do not have an attorney.
I did have one appointed, but I was incarcerated in Tennessee. So it's got,
It'll continue.
I'll move around.
Okay. You're here today for the purpose of arraignment. You have the right to remain silent. You have any question, step away from the microphone and ask your attorney. The grand jury of Monroe County has issued an indictment charging you possession of controlled substance, first degree, possession of drug paraphernalia. Counsel, you acknowledge the identity of your client, received indictment, await formal reading and arraignment, and a plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order here, sir, that will require the Commonwealth to provide your attorney with all the evidence that they have to help you prepare for your case. You want him here on the negotiation day? You're here to be here at 9 a.m. on January 12th for negotiation, and your next court date's January 18th. Both of them, Mr. Newberry, are conditions of your bond, okay? Jonathan Russell. Jonathan Russell. Twenty-three CR 0012. Are you Jonathan Russell? Born in 1978.
Yes, Your Honor.
Let him on your inside here, so you get on this side over here. That way, when Mr. Stockton comes rushing up there, he won't have to go through you. What are the last four digits of your social security?
142, Your Honor.
We're here for a pretrial conference, Mr. Bell.
We're gonna be trial date, Judge.
What is the charge?
It's an assault, wanton and dangerous charge.
Okay.
I'll take 2 days.
How about your witnesses?
Well, I don't think we'll have any trouble getting any of the witnesses.
Okay.
We've got a victim, and then we'll have some medical proof.
Okay.
Judge,
That's true. That's true. You might ask him if he wants to do that before he has the trial day.
when we were negotiating that, Judge, there is a minor involved as I think would be the main witness for the Commonwealth. We had discussed doing a competency hearing concerning.
How old
that
is
witness.
tonight?
I'm trying to remember, Mr. Russell.
Is she 12? 12,
She's 10.
10.
I was thinking 8 or 10. I couldn't remember.
She's saying that time.
It's that time. So the court wants to do that before. Or we will need to have comments.
Schedule that hearing for January the 18th. That's the trial date. And if the witness is found not to be competent, you can make your decision as to whether you want to proceed or not.
Go ahead and do it.
What about January 29th and 30th?
Cause I got a federal sentencing on the 29th.
How much they gonna give you?
a substantial amount. They're not stingy.
Oh, you're representing someone down there. I didn't know.
Yeah. Yeah. I told them they'd already had the chance to speak. Judge. I'm done.
How about March 11th and 12th?
That's fine with me.
That works for me, Judge.
Great.
Thank you, Judge.
Thank you.
And you have the competency hearing on the 18th. You realize that he's got a right to be present.
Yes, sir.
I guess the victims will be notified about the 18th also.
That's all right. We'll do an order that we're having a hearing that day and I'll get us.
I think that would be good.
In other cases, I've filed motions, Judge, but due to the fact we've agreed to do this, anybody need to file any motion or just show up on the 18th to do it.
Say that again.
In other past cases, I've always filed a motion.
Oh, I thought you were talking about other cases you had going on here.
No, sir. No, sir.
I think it would be good if you had a motion sitting out something, but I guess, or you could just do an agreed order on to a hearing to establish the competency of a proposed witness would be the best way. You agree to do that?
That's fine with me.
Thank you, Judge.
Okay. Joshua Vincent.
Judge, Mr. Vincent is in federal custody, and I believe that's he's supposed to be on right now.
It's Mr. Muse.
Yeah, that's Mr. Muse.
Oh, he's in federal custody. He wouldn't be back.
Last time we had someone in federal custody, they said we had to go to the marshal's office to even get permission for them to appear on Zoom.
I've been through all of that. They agreed to let him be on. I just need to, I don't know.
Is he still in Warren County?
Where's that?
Is he still in Warren County?
I'll text Judge and see if you would allow me to pass this and hopefully get him on today.
Pass it and we'll schedule it for another day, certain. Okay.
That'd be the 18th.
Maria Ziola. If you get a hold of him today, Mr. Bell, we'll go ahead and enter an order today. I'd like for you to be in contact with him today so we can set a date certain so you can go through the process.
Yes, sir.
Then she downstairs with politics.
Okay. Do we have Allen County detention on? Allen County's not on. We have Blackburn Correctional Institute on. Blackburn, if you'll turn your camera on. Blackburn Correctional Complex.
You need more time.
Your Honor, we're still trying to find our inmate for court this morning.
You're trying to find him.
Yeah, he was at lunch.
Okay, well.
We're just trying to get him down to my office, sir.
Okay,
We
well.
were scheduled to start at 11 a.m. and so we were trying to get him here early. I connected early. I apologize for that.
That's okay. When you get him there, just turn your camera on and we'll see you, okay?
Absolutely, Your Honor. Thank you.
Clinton County, the case in the Wayne County Detention Center. Is Wayne County on there?
You want stipulated, but we need to have here.
Okay.
And Judge, I did do a transport order for Miss Owenby. I think with the timing, I submitted it Monday. I don't know if it got it to her or got to Wayne County.
You gonna stipulate as to her competency, did you say?
Yeah, or like thereof, yes, Your Honor.
Yeah, lack thereof, I should say. And I guess what we need to do is set her on the January 5th for negotiation, see if we can get it resolved. That's the Clinton County
She's
negotiation.
not competent?
I thought she was. She was the last time I looked at it.
Well, I don't, are you stipulating
Oh, yeah, hold on.
as to her competency or as to her incompetency? I don't know.
It's my opinion, she meets the criteria for mental and does not meet criteria for intellectual disability.
And he says, it's my further opinion,
She
Ms.
has-
Gumby lacked the capacity to appreciate the criminality and conform her conduct
Yeah,
at the time.
she's competent, but doesn't have criminal responsibility, according to the psychologist. And so in under those circumstances, if he'll stipulate to the competency, we can proceed with the negotiation day and see if we can resolve this.
Okay,
And I will, Your Honor.
okay. Well, she's not here, so we'll probably get,
Yeah, we'll do
And
an
I-
order of that.
And I'll have her sign the agreed order.
make sure there's a signature place on there for her too, okay?
Okay.
Since she's not here today, okay?
Yes, Your Honor.
Okay. Where did Mr. Bell go?
He's outside calling the
Oh,
federal
yeah,
government.
okay. Well, Barron County starts at 10:30, so we're caught up except for a couple cases we passed over. Is Mr. McClendon processed? Is he ready to come?
They're the two that are working on it. They had a little trouble getting into my computer this morning.
Yeah.
Go down and get it started. So
Okay.
it's.
Have you had an opportunity to talk to Mr. Roca, Mr. Bell?
Judge.
I thought he was, yeah, that's your client. Okay, I still see your name on there. I'm sorry. Mr. Ping, have you talked to him? Okay, let's go off the record.
We got an email yesterday.
Just a special. Okay, Blackburn Correctional Complex, Commonwealth, Kentucky versus Terry Muse. 23 CR 0046 for a pretrial conference. Are you Terry Muse?
Yes, Your Honor.
Okay, your year of birth is 1985.
Yes, Your Honor.
Last four digits, social security number 2055. Is that correct?
Yes, Your Honor.
What does the Commonwealth have to say? Mr. Stop.
I don't know if Mr. Pennington's been able to get up with Mr. Muse or not since
We
he's
just,
in Blackburn.
we just need one more negotiating day, Your Honor.
January the 12th for negotiation day. And the next court appearance will be January 18th. Mr. Muse, your attorney, are you going up there to see him?
I will, and I'll have a transport order for him as well.
Okay, they'll be up to see you and you'll be brought back down here for a negotiation day on January the 12th. And your next court appearance will be January the 18th. And your attorney will be up to see you this week. Is that correct? Or next week?
Either this week or the first next week, Terry.
Okay. Thank you very much, Blackburn. Thank you, Mr. Muse. Let's go to Allen County. Blackburn, you excused. I'm gonna take a few minutes in. Okay, let's go to Allen County. Commonwealth, Kentucky versus Andrew Dover. Are you Andrew Dover?
Yes, sir.
Were you born in 1999, Mr. Dover?
Yes, Your Honor, I was.
Last four digits of social security number 0708. You're here today for, is that correct? 0708, last four digits?
Yes, sir, it is.
Okay, you are here today for the purpose of arraignment. You have a right to remain silent. Your attorney is here and present. Say something to key the mic.
Hello, Andrew.
Hello, sir.
Okay. The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance in first degree methamphetamine. You understand what that charge is?
Yes, sir, I do.
Okay, I'm going to sign a reciprocal discovery order here. Commonwealth will have to give your attorney all the information they have to allow you to prepare for your case. You're going to have a negotiation day on January the 12th, and your next court date is on January the 18th. Your attorney will be to see you, and we'll have you transported if necessary on both those days. So you'll be here in court. Okay.
Williams, Monroe County pretrial had called and asked if I wanted to do drug court.
Okay, we'll talk about that, Andrew.
All right.
Okay, he'll be up to see you. Okay, thank you.
Right. Thank you, sir.
Yeah. Allen County, we don't have anybody else over there, I think. So thank you for your cooperation. You may be excused. Now, do you have any of the people downstairs who are being processed ready to come up?
There should be just about that.
Okay,
Judge, as a point of order, we're ready to do Mr. Roca's plea.
glad to do that.
Stacy, you probably got ready to set a trial.
Okay, we're coming back to Commonwealth of Kentucky versus Alvin Roca. Mr. Roca is previously identified his year of birth, last 4 digits, social security number. There's some plea documents that have to be done. The Commonwealth want to come over. Go ahead.
Yes, it'd be a felony plea, Your Honor,
Okay.
on 23 CR 62.
Now explain to me what's happening with these other cases now.
He's got an 18 CR.
62, he's already got a shock probation revocation.
Yes,
The one I have that's outstanding is 20 CR 0057. It's what it's got on the docket.
I've got that wrong. It's 2362 is a pretrial.
Okay, it's just reversed. That's okay.
that's, yeah. And the other two have already, he's been sentenced on, so.
Okay.
Yeah.
The motion been tendered says you wish to enter a guilty plea today, sir. Is that correct?
Yes, Your Honor.
Okay, you're currently under the influence of drugs or alcohol.
No.
This plea freely and voluntarily given.
Yes.
Are you the same person that is indicted in? Should I get the right one? 23 CR 0062.
Yes.
Is this, is your judgment impaired today?
No.
You're doing this freely and voluntarily, correct?
Yes.
You discuss this matter with your attorney and you feel like you're fully satisfied with his advice?
Yes.
Do you understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to a higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a plea of guilty today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, though they apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I'll await the pre-sentence investigation report done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea on this case and proceed to trial. Mr. Stockton, you want to go over and go into detail just a little bit more?
Your Honor, Mr. Roca will plead guilty to trafficking in a controlled substance, first degree fentanyl, receive a sentence of 5 years to serve. That will run consecutively with 18 CR 206 and 20 CR 57 for a total of 11 years. The Commonwealth opposes probation or shock probation. He'll forfeit the $460 in the 2003 Cadillac. All evidence in this case will be destroyed. In this case.
Is that what you agreed to, sir?
Yes, sir.
Okay. Now, is he a state prisoner now? If so, how is?
He will become a state inmate today.
Okay, so the previous pre-sentence investigation report, though, was prior to the revocation of these other charges, so we'll need to do another one.
Yes, sir.
Okay, we'll have you come back here on January the 18th for sentencing. We'll make sure the transportation order is done. Okay,
And Judge, just as a point of order, do you want to verify Mr. Roca's signature on the motion?
is that your signature on it there?
Yes.
Okay, thank you very much.
Thank you, Judge.
Thank you very much. Yeah. Is Mr. McClendon ready? Now, Joshua Vincent, what?
Thought we said him for 18.
Need to formally, that's 22 CR 001 and 21 CR 00132. He's in federal custody. We're setting the date for January 18th so the defense counsel and prosecutor can contact the United States Marshal's office to set up a Zoom. Is that correct?
Yes, sir.
And then Maria Zioli. She'll be in process. Okay. So we just have two people off this docket transported that aren't here today, out of custody people. And at 10:30, we're supposed to go to Barron County. So we're still 18 minutes early. Let's go off the record.
Hey, Can you check and see if I can get them up there before 10:30, because I've got a special prosecutor on this case. This is taking entirely too long. They just turned themselves in today.
Yes, sir.
Not, I'm ready to let them sit in jail for a month. There we go.
This one hooked up to it, so we don't process it through that.
Where's the other ones? Good.
Yeah.
The other card is good.
That's what I said, I've linked.
So you won't send them both for.
Both of those good now.
I make a note to send
Well, I
James
needed
and
more
Sylvia on the text and Smith just going through next week. That- It's another possession.
Well, I saw it, and it looked like about time anyway, so.
Maybe my pipes won't freeze now.
You want it now?
Wasn't sent to me. What? Telling you, she's here in court. We can do it.
I've got some back and forth, Judge, if you want to take her up.
Why, sure.
Alice Goodman.
What docket did they appear on?
I'm sorry, Judge.
What docket? I'm asking which, on my docket sheet is. Bill trying to slide somebody in here. Let's see.
I go slide her out.
I'm looking, okay, let's go back on the record, I guess.
Stand right here, let me stand.
I'm of Kentucky versus Alice D. Goodner, 22 CR 0048. Are you Alice D. Goodner?
Yes, sir. Yes, sir.
You're here today for the purpose of sentencing.
Excuse me?
Give her come over here and get her. Somebody's hearing things. You don't have anybody else
He
left.
coughed.
Do what?
I couldn't hear him because he coughed. I'm sorry, Okay.
Is that better?
Yes, sir. Yes, Your Honor.
You're Alice D. Goodner and you're here today for sentencing. Is that correct?
Correct.
You had an opportunity to look at the pre-sentence investigation report done by probation and parole. Is it substantially correct?
We've not seen that, Judge. I'm sorry.
I'll give it, here, you can take this copy. I mean, if you come here for sentencing, Mr. Bell, and you hadn't seen the pre-sentence investigation report, something's up.
It is, Judge.
Okay, well, you've got it now. Let's look at it.
Yes, sir.
It's that kind of day today, so have her sit over there and look at it. You can go out there. Are there rooms outside these doors here, conference rooms? Take her out there to those conference rooms. Okay, let's go back off the record. They must be taking DNA samples for these people that they're booking down there in process. I've never seen that.
I just wondered why they just showed up today of court. That's Clinton County.
Didn't want to be in jail.
Yeah, it's a Clinton County deal, so solid. Where was that guy the other day that called in? He was in Arizona or somewhere, and I got an arrest warrant out, and he called in our office the same day on child support. He knew about it.
No, it's not child support. It's where he shot Joe Daly.
That's what it was. Yeah, he was in Arizona.
Tucker, John Tucker.
Yeah. Wanna know how you could get it taken care of, I guess. So we'd have to come-
No, he's already calling. I actually got a picture of the license. I got to know Mr. Binghamton yesterday. So I couldn't know that. Get out and check the car.
I just realized it. Since we got a break, I'm gonna go down and look at it. That's great. Perfect. It is right here. That's good.
Better day than you thought.
Could have been worse.
Before she does, so when I get up, I'm just like, that's something simple and easy. If she does it first, I don't care to create the messes. When you get back up, I'm just like, forget it.
Hey, Lenny, could you guys ask you a question here? Am I correct? Am I correct that if you have LLC property or that is listed for tax purposes under the name of the LLC, real estate property tax, is that right?
Yeah. Yeah, I think that the tax situation still flows through to you.
Yeah, but as far as owning property, let's say that you and I formed the LLC for real estate development purposes.
Yeah, it would be listed that way.
It'd be listed, and we'd have to deed it over to the LLC.
You sure do, or you got a problem if you need it.
Yeah, thank you.
Still tied up on Sunday night?
You know, I don't know. I haven't thought about that.
If you're free to election come out there, it's on. Before you get to, right after you go through Newtown Place, go underneath that, it's a big house on the right.
I'll be in contact. Okay. Thank you so much.
Is there anything on the estate?
Yeah. Well, I filed it, for what they add up the figures.
Do what?
Mr. McLean and Miss Ziola's in the courtroom.
They are.
But you could check, and that's
Yeah.
why I didn't do anything. to get
I was
that
just
done.
making sure.
No, we got.
I was still waiting.
Me too.
Evidently, they're in the courtroom here. Let's go back on the record. Commonwealth, Kentucky versus Robert McClendon. Has he been processed?
He's not been processed yet. I brought him up, because they're bringing on up.
I just thought evidently Lucas was starting to process, and then he got called to grand jury, and Ricky's been having problems with Florida.
Okay, well, we'll
And
just
they've
go
been
ahead.
hiding out so they couldn't get served. Now they show up here in court and
Yeah.
they're dumb enough to work.
Okay, we'll just take him in custody. You're in custody. Oh, okay. What about Miss Ziola? There are not warrants out for her, are there?
It was just served.
Just served. She's been processed.
I think they were working on it. Yeah. Are you done?
Process on one.
Commonwealth, Kentucky versus Maria Ziola, 23 CR 0068 and 23 R 0071. Here for the purpose of arraignment on one of them, I guess, or maybe.
You just got, I've got. You got meetings there. Yes, right. I'm gonna keep track.
Okay, this is 23 CR 0071, Commonwealth, Kentucky versus Maria Ziola. Assault in the second degree. The grand jury of Monroe County has returned an indictment charging assault in the second degree. And in 23 CR 0068, grand jury of Monroe County has returned an indictment charging you with theft, unlawful taking or disposition, auto 1,000, but less than 10,000 class D felony, and burglary in the second degree, as well as prostitution. You understand those charges, Mr. Bailiff? You, Counselor, you acknowledge the identity of your client received indictment, wait formal reading and arraignment, enter plea if not guilty.
I did, Your Honor.
Has she made bond yet?
She made a bond down in district court of 10% of 10,000. I think the bond right now is set at 10,000. If the court would be willing to transfer her bond.
We have a special prosecutor this
Yeah, she's
case.
got two cases. I've got one of them. Mr. Thomas got the,
Okay,
I've got the assault case.
well, how long have these warrants, but these indictment warrants been out for her?
So November 17th.
Yeah, November 17th. She's had time to get to Mr. Garrett. She hadn't had time to come to herself.
I was retained in the district court, Judge.
Okay, what, do you want to have a negotiation day on the 12th? And then the next court date's on the 18th on both of these cases?
That's fine with me.
Why do we have a special prosecutor in the case?
Because I'd have to get a flow chart out to explain that Mr. McLean is both a victim and a perpetrator of lynching. Mr. Viola is involved in McLean. I don't know what time before, but I've got a source
Well, if there's just two of them, it'd be hard to make a triangle out of it.
There's another fellow involved too, Mr. Wall. It's not very much.
Well, I don't understand where you've been since this indictment. I mean, why did you show up here? How did you know to be here today?
My husband told me,
Who is your husband?
Jason,
Who?
Jason McLean,
He told you need to be here today. So he knew he had to be here today. And when did he tell you this?
yesterday. I have property in Tennessee. That's where I've been.
You live in Tennessee?
No, sir.
Do y'all have anything to say about the bond?
Well, it needs to, it's an assault second charge and it's felony charge and
What is her bond now?
10,000 cash for both of us.
Or 10% property, they said.
No, she posted a 10% of a 10,000 bond in district court.
In district court. Yeah. Okay, now, well, I'm not gonna change the bond, so. Have a bond here if you want to. She's staying down in Tennessee, appears to me to avoid process. She says she lives here, but she's been down in Tennessee with us with this indictment warrant, so that doesn't give me a lot of secure feeling about her attendance, so you can file a motion if you want to. Okay, thank you very much. Now, I guess, Mr. McClendon, what's Mr. McClendon's bond?
you got Charles Means. Is he been served?
Take her into custody.
He is. So he'll be called.
He has a $10,000 cash bond.
We'll see him on January the 18th.
Looks like he posted $2,500 bond in district.
Ken, are you representing him too? Are you representing?
I've got her in the 68 case, the assault, I wouldn't aware of.
Oh, so you're not in you're not in the
Well,
same.
I guess I'm in it as having stood up there, but. Just
What about Robert McClendon?
Yeah. Yeah, I'm just gonna pass this right now. Well, I can go ahead and arraign him, I guess. Does he have an attorney? Let's bring him back out and arraign him. Robert McClendon. Give me Robert, give me.
Yes.
Okay, now, Commonwealth of Kentucky versus Robert McClendon, 23 CR 0072, y'all Robert McClendon, born in 1972. Last four digits, social security number 9729. Is this your client, Mr. Pennington?
Yes.
Yeah.
Yes, Your Honor.
Okay.
He is not.
The grand jury's returning indictment. You have a right to remain silent. Grand jury's returning indictment charging with assault in the second degree. Theft and lawful taking disposition in criminal mischief second degree. Here you go. Mr. Pennington, you acknowledge the identity of your client received indictment, away from where you can arraignment or plead not guilty, reserving all pre-trial motion.
Yes, Your Honor.
Okay. Schedule a negotiation on January the 12th. And the court date on January 18th, and I'm signing a reciprocal discovery order here. Commonwealth has to provide you with all the evidence they have in preparation for the case. What is his bond?
I think it's 10 cash.
10,000 cash. Okay. Okay, you can have somebody come make your bond if you want to until then you're in custody of the jailer, okay?
Could I ask for bond reduction, Mr. Williams?
No, your attorney might make a motion.
Make a motion.
You can file a motion. I'll be glad to hear that.
Thank you.
The reason I'm not letting you do it today is because you're only allowed one of them. And if you're not prepared for it, I don't want you to waste that one. You understand what I'm saying? By law, you're allowed one bond reduction, and I will hear that. Okay, unless the Commonwealth reaches an agreement with you. Okay, thank you very much. Okay, does that finish the docket except for Barron County?
That's, I can tell, Judge Ron.
Okay,
Oh, I forgot about her.
where is she?
For some reason, she's not on my list.
Oh,
No, she's not on next.
we needed more security up here. Where is the button at?
Underneath. It's unhooked.
Me too.
I need the sheriff to send more bailiffs up here. You cannot handle this place by yourself. Tell them I want more bailiffs up here. I'm sorry for reaching for it. You see a red dot, dodge.
You missed me at Rudy.
Yeah, okay.
May I approach
She's
you?
not on the docket here today.
She's been overlooked, but I gave you the PSI.
Yeah, well, I gave it to him.
Oh, yeah.
You passed to another time.
No, that's okay. Okay, this is 22 CR 0048, Commonwealth of Kentucky versus Alice Gooding. You're here for the purpose of sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Okay, is it substantially correct?
Yes, sir.
Is there any reason this lady should not be sentenced?
No, Your Honor.
On plea of guilty to operating a motor vehicle with alcohol concentration of 0.08 or under the influence, the defendant shall pay a $200 fine and court costs on plea of guilty possession of controlled substance. First degree defendant shall receive a sentence of 3 years, pretrial deferred for 5 years. Defendant shall be referred to social service clinician and follow any and all recommendations. The defendant shall receive credit for time served. And what are the court costs? $615, and you can pay it at $40 a month starting 30 days. You've already paid some on it, okay?
Yes, sir. Yes, sir.
Okay, now, you were informed that this DUI, if you get another DUI, it's enhanceable. You were informed of that when you pled, correct?
Yes, sir.
Okay, and then this possession case that you're on the pretrial diversion, you were informed about that. If you violated, you'd be a convicted felon. Is that correct?
Yes, sir.
Okay, well, you want to meet your probation parole officer. Okay, let's go off the record here.
Am I done?
Let's go off the record for a second. Come up here for a second. Mr. McClendon,
Yes, Your Honor.
you've disrupted this court by going back there and kicking the door. I don't know what you're thinking, but we're just trying to process you through this thing.
Okay.
Now,
I'm sorry,
well, okay. Now, if you cause me any more problems, I'm going to put you in contempt. I can put you in for 6 months. You understand that?
Yes, Your Honor.
I will not hesitate to do that. Okay, thank you very much. Take him back out. Okay, let's go on to Barron County Jail if they're on there.
We're here, Your Honor.
Okay, thank you so very much.
You're welcome.
Commonwealth versus Jonathan Brown.
Please, court.
Are you Jonathan Brown?
Yes, sir.
Mr. Brown, were you born in 1976?
Yes, sir.
Last four digits of social security number 0306.
Yes, sir.
You're here today on 23 CR 0064, a pretrial conference, and 21 CR 00111, a probation revocation. What does the Commonwealth have to say? Mr. Stockton, you'll need to come up here so we can get you on camera.
He has also he has a new felony charge along with the revocation. Mr. Bell has requested of me one more pretrial on this case before we set a trial date, but I've told him if we can't resolve all cases by January 18th, I'm gonna get a trial.
So you want a January 12th negotiation date and a January 18th trial date. Your attorney will be over to see you, Mr. Brown, to discuss this other indictment and the resolution of the thing, and he'll be over there before the January 12th date, so you can be prepared for negotiation on that date. You understand what I'm saying?
Yes, sir.
Okay, thank you very much.
Thank you, Judge.
Willie Daniels. Commonwealth versus Willie Daniels. 23 CR 0013. Are you Willie Daniels?
Yes, sir.
Born in 1997.
Yes, sir.
The last four digits, social security number 2134.
Yes, sir.
Okay, you're here on a motion for shock probation. What does the Office of Public Advocacy have to say?
Judge, if I may, Mr. Daniels is actually seeking to withdraw that motion, given his parole eligibility.
Okay. Your attorney advises that since your parole eligibility is better, they think that's a better avenue for you. Is that correct?
Yes, sir.
Okay, we'll be glad to do that. Good luck to you.
Sir.
Stacy Eden. Are you Stacy Eden? Were you born in 1989?
Okay.
Last four digits, social security number 3700.
Okay.
Okay, you're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, I don't know if she got on pretrial because there's an agreed order for her to go to KCP.
That's what I was getting ready to say. Yeah,
Judge, I think she was placed on the docket in error.
She already entered a plea
No, Your Honor, she's away. There's an agreed order in the
or an
record.
evaluation?
Yes, Your Honor.
Okay. Okay, well, they'll be over to see you about your evaluation then soon this evening, okay? Thank you. Kara Foster. Commonwealth versus Kara Foster, 23 CR 0058. Are you Kara Foster?
Yeah.
Born in 1979. The last four digits, social security number 8823.
Yeah.
You're here for a pretrial conference. What does the Commonwealth have to say?
We have a felony plea, you know.
Ms. Foster, a motion has been tendered to me that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23 CR 0058?
Yeah.
Is your judgment impaired today in any way?
No,
Have you discussed this matter with your attorney and are you satisfied with his advice?
no,
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
no,
You understand? You said you are fully informed about your case?
yeah,
I don't understand what yes or no?
yes,
Okay. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept your plea, I need to know that you understand those rights. You have the right not to testify against you. No one can say anything. The right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea today, you give up those rights. You understand that?
sir,
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will wait the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, what is the Commonwealth's recommendation, Mr. Stockton, if you'll get behind the podium there? Listen very carefully, man.
Your Honor, Ms. Foster plead guilty to trafficking in a controlled substance, first degree, a Class B felony, receive a sentence of 3 years to serve. She'll receive credit for time served. Commonwealth opposes probation and shock probation.
Is that what you agreed to, ma'am?
yes, sir,
Are you pleading guilty because you did commit the acts charged in the indictment?
yes, sir,
Are you doing so your own free will?
yes, sir,
On your constitutional rights, it's still your desire to allow the court to fix your punishment in the range permitted by law.
yes, sir,
You understand that any future felony convictions could be enhanced range of penalty because of this plea here. You understand that? Hand me the document for the bailiffs. Yeah. I got it here. Oh. Is that your signature on there, ma'am?
yes, sir,
Okay. Well, I'll accept the plea, order pre-sentence investigation report to be done, and schedule a sentencing for January the 18th, okay? Thank you very much. Matthew Hagan. Matthew Hagan for arraignment. Commonwealth of Kentucky versus Matthew Hagan, 23 CR 0073. Are you Matthew Hagan?
Yes, sir.
Born in 1987, sir?
Yes, sir.
And the last 4 digits of your social security number are 6854. Is that correct? Is that correct?
Yes, sir.
54. The grand jury of Monroe County has returned an indictment charging you with assault, 4th degree, 2 counts, and burglary in the 2nd degree. Your attorney is here. I'm handing him the indictment. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
I do, Your Honor.
I'm signing a reciprocal discovery order, Mr. Hagan, that will require the Commonwealth to provide information that they have that will help you prepare for your defense. We will schedule a negotiation day on January 12th, and the next court date will be on January the 18th.
Judge, would the court consider doing a $5,000 cash or property bond?
What's the bond now?
I'm
What's
not
the
sure. I
bond?
think it's
Y'all over there?
It is, it is 10,000 cash. He's coming back as a moderate risk on both scales.
You'll need to talk to Commonwealth unless you want to hear, and I'd be glad to schedule a hearing for you.
Thank you.
Thank you very much. Dustin Jesse is next. Dustin Jesse. Commonwealth versus Dustin Jesse, 23 CR 00010 for sentencing. Are you Dustin Jesse?
Yep.
Born in 1991, Mr. Jesse?
Yep.
Last 4 digits, your social security number is 0707.
Yep.
Judge, I don't think a PSI was completed because he went into custody in Barron County. Spoke to Mr. Collins earlier.
Your Honor, we didn't know, certainly correctly, I believe we had issues here that are already about. We didn't know he was back. We didn't know he was back in custody. That's close to.
Yeah, I'll schedule, hold him without bond and schedule him for sentencing on January 18th. There's a bond modification because he absconded. Thank you. Commonwealth versus Charles Muse. Commonwealth versus Charles Muse, 23 CR 0069. Are you Charles Muse?
Yes, sir.
Okay, you're here for the purpose of arraignment, Mr. Muse. Were you born in 1976?
Yes.
Last four digits for your social security number 7778. Is that correct?
Yes,
You have the right to remain silent. The grand jury of Monroe County has returned an indictment charging you with possession of marijuana, public intoxication, theft, unlawful taking, or disposition. And burglary in a second degree. You understand what those charges are?
Yes, sir.
Okay, Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, we'll schedule a negotiation date on January the 12th and the next court appearance on January 18th, and both of these are conditions of bond. Now, this is the other party according to the indictment that was involved with the Jason McClendon and the other lady. Is that right?
Yes, Your Honor.
Okay.
So Judge, and I'll reach out to my office. We may need conflict counsel for Mr. Muse as well.
Well, so that's the reason I'm bringing it up. I saw it in the indictment.
Yeah, I'll check into that too.
So we'll do that.
Absolutely.
Sooner rather than later. They're
Yes,
gonna,
Judge.
Mr. Muse, they're gonna check to see the public advocate's office is representing Mr. McClendon, and they're gonna see if they need to get another outside lawyer to represent you to avoid the conflict of interest, and they'll be in contact with you about that, okay?
Okay, can we do anything about the bond, maybe recess it or?
Well, they'll, when you get your new lawyer, they'll contact the Commonwealth attorney, and we'll consider that, okay? Thank you very much. Brian Roberts. Commonwealth Kentucky versus Brian Roberts, 23 CR 006. We're here today for sentencing. You are Brian Roberts. Were you born in 1992?
Yes, Your Honor.
Last four digits of social security number 2853.
No, 7584 is the last four digits of my social.
Yeah, that's right. 7584. I looked one above there. Good catch, man. Okay. Have you did you look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yes, Your Honor.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
No, Your Honor.
Give me a little background again on this.
Yeah, this is the matter occurred back in June of 2020, and after this incident, Mr. Roberts was indicted, I think for possession of a controlled substance. He was in a drug court. There was a revocation hearing regarding the infraction on that, and I think there was a 9-day sanction.
That's correct.
You need to get behind the microphone.
While that was pending, the revocation was pending, I gave Mr. Cross a contingent offer, one to serve and then one for probation if his probation was not revoked in the the other matter. And I think the court gave him a sanction. So Commonwealth agreed to the probation. There's the defendant, the alleged victim in the matter is a defendant as well in this court. And there is a fact issue whether this was self-protection or protection of others as well. And the Commonwealth would have a difficult time proving the assault.
Was there a knife involved in this?
There was.
What does the victim have to say about this sentence?
Your Honor, I don't know if I've had contact with the victim.
Don't we have to have contact with the victim under the new constitutional amendment?
I can, Your Honor.
Do what?
I can do that if you want to recess sentencing and do that.
I think we've got to do it. So I'll reset the sentencing on January the 18th. Even though the victim might be accused of a crime, I think they still have a constitutional protection under the law to be consulted about things. So we'll take it up on January 18th. Okay.
I understand.
Okay, thank you.
Get my things together.
Mr. Roberts, we're gonna reconduct your sentencing hearing on the 18th of January, okay? And myself and Mr. Cross will be in contact with you to answer any questions you might have, okay?
Your Honor, could I at least have to get my things together and get my medical statements put together, get my insulin and stuff for jail? I'll step right back in.
Mr.
Okay, wait just a second. You call him. She's gonna call you right now, your attorney is, and get you on the phone and talk to you about any needs you might have, okay?
Okay.
Okay. Some of those things are private and you shouldn't have to talk about them in public, okay?
All right.
Okay, she'll call you. Patrick Scott. Commonwealth of Kentucky versus Patrick Scott, 23 CR 0048. Are you Patrick Scott?
Yes, sir.
You born in 2001?
Yes, sir.
The last four digits of social security number 0480.
Sir.
Okay, we're here for a pretrial conference. What does the Commonwealth have?
We have a felony plea.
Well,
We did have.
Come around here. There seemed to be some reticence on defense counsel.
Judge, Mr. Scott has.
Want to get behind the microphone?
Yeah. Mr. Scott has a case in Barron County that he goes to court on Monday on. He is expected to enter into a diversion plea. So my understanding is we're prepared to enter into a plea, but if he enters into a plea today, he will be ineligible for diversion in Barron County on Monday.
What is the charge here?
It's wanton endangerment, 10 count.
And just, we have no problem with the deal. It's just the timing of.
What was the deal here?
It's 10 years, serve 180 days, enter into the drug court and plead guilty to DUI, $250 fine.
And Mr. Scott has not got close to his 180 days yet.
What kind of cases he got over there?
It is a fleeing and evading.
Same incident, just a different incident. It happened while he was out on this one?
I think this one happened while he was out on that one.
Correct.
This one in Monroe County happened while he was
They're gonna let him do a diversion when he was out on with a DUI and all these counts while he was out on bond on this.
So they're hoping to do that in Barron County. He's not getting a diversion.
Yeah, not, he has a diversion deal in Barron County, Judge.
But do they know about this charge here? Not your responsibility to tell.
Judge, I don't know.
I think they're about to.
Yeah.
But we'll reschedule this. When you want to reschedule this?
Well, next court date's the 18th.
January the 18th, and we'll see what they do over there.
Thank you, Judge.
Orlando Shirley. Commonwealth versus Orlando Shirley. 21 CR 0096. Are you, Mr. Shirley? Orlando Shirley.
Just a second, Your Honor. Can we get Orlando Shirley wrong, please?
I'll go ahead to, I'll come back to Orlando. Jackie Short. Commonwealth versus Jackie Short. 23 CR 0065. Are you Jackie Short?
Yes, sir.
Were you born in 1970?
No, sir.
What year are you born, Mr. Short? What's your year of birth, Mr. Short?
1990.
1990. Well, you just gained 20 years of life and you hadn't been in front of me for 2 or 3 minutes. You're doing a pretty good job there. Last 4 digits, social security number 4616.
Yes, sir.
Okay, you're here on 23 CR 0065 for a
That's when I didn't
pretrial
get
conference.
discovery until Friday.
What we got here? Mr. Stockton?
This one, we need another pretrial on. Mr. Pennington just got discovery on.
Pretrial for the 12th. And next court date's the 18th. What's the gentleman charged with?
Possession of controlled substance, Your Honor.
And Judge, if regards to bond, he's being held on other charges as well.
Okay. Okay. Thank you very much. They'll give you a transportation order. Jason Smith. Jason Smith. Jared Smith. Jared Smith.
Was on docket and missed.
Tiffany Spalding.
Feeling that Jared's in here. Jared is in here, Your Honor. He just didn't hear his name.
State your name, please.
Jared Smith.
Jared Smith, 23 CR 0016. Mr. Smith, were you born in 1992?
Your Honor.
Last 4 digits, social security number 4515.
Judge, may we approach?
You want Mr. Stockton
Yeah,
with you?
yes, Mr. Stockton.
Okay. You can't approach without being broadcast. It was me. Mr. Smith, we're going to come back to your case. Tiffany Spalding, is Tiffany Spalding in there? Michael Turner.
Judge, Ms. Spalding is here and we have a resolution.
There she is. Tiffany Spalding, 23 CR 0053. You are Tiffany Spalding. And you were born in 1992, is that correct? Last 4 digits, social security number 5808. Okay, we're here today for pretrial conference. What do you have?
Judge, we have a plea diversion.
Ms. Spalding, a motion has been tendered that says you wish to enter a plea today. Is that correct? You have to speak up.
Yes, sir.
Thank you. Are you currently under the influence of drugs or alcohol?
No, sir.
Plea freely and voluntarily given.
Yes, sir.
Are you the same person named in indictment number 23 CR 0053?
Yes.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Feel like you're fully informed about this case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over them. At the end of them, I'm gonna ask you, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, the right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge. You understand? But entering this plea, you give up those rights. Do you understand that?
Yes.
Now, may consider the Commonwealth's recommendation that I may apply any range of sentence provided below. I don't have to accept the recommendation. If I don't accept the recommendation, you and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Now, I'm going to ask you, I've been informed that this is a pretrial diversion. Have you previously been diverted in the last 5 years?
No, sir.
Have any felonies in the past 10 years? Are you currently on probation?
No, sir.
You understand if you complete this pretrial diversion, the charges will be dismissed, pretrial diverted, and you can have your record expunged. Do you understand that?
Sir.
However, if you don't successfully complete the diversion, you'll be brought back before me, and the court will decide whether to revoke your pretrial diversion and schedule a sentencing. In that situation, you'll be a convicted felon, and future convictions could be enhanced as far as penalty because of that. You understand that? Now listen very carefully to see what the Commonwealth's recommendation is. Mr. Stockton.
Your Honor, upon a plea of guilty possession of controlled substance first degree, she'll receive a sentence of 3 years, pretrial diverted for 5 years, supervised. She'll receive credit for time served. She'll obtain and maintain gainful employment once she's released, and all evidence in this case will be destroyed.
Is that what you agree to?
Yes, sir.
Now, has anyone, including your attorney, threatened or coerced you in any way to get you to enter this plea?
No, sir.
Your own free will because you did commit the acts charged in the indictment as amended. Is that correct?
Yes.
Okay, now hand me the document up here if you would. So much. I'm going to show you a signature, see if it's your signature on it. That's your signature. That's your signature right there.
Yes.
I accept the agreement. And when can you schedule? She's not a drug court person or anything. When can you schedule to interview her?
If she can come to Glasgow Monday, the 18th, I can get her took care of that.
Okay. Well, I'm going to do something I don't usually do. I'm going to go ahead and let you out. You be at the probation and parole office at 8:30.
That's fine. Yes,
8:30 on Monday morning. Okay. Now let me give you a little suggestion. Between then and now, you do not need to celebrate your exit from jail. You understand? You need to live at the foot of the cross between then and now, because they might test you when you come in there on Monday morning. It'd be an awful thing to get revoked on your first day. Okay. So the document will be over and they'll let you out today. Okay.
Thank you.
Thank you.
Thank you, Judge.
Yeah. Michael Turner. Michael Turner.
Yes, sir.
Okay, Commonwealth versus Michael Turner, 23 CR 0055. Mr. Turner, were you born in 1967?
Yes, sir.
That's 4 digits, your social security number 1161.
So,
We're here for a pretrial conference. What's the story here?
Judge, you may not recall last time, Mr. Turner actually fired me. I have contacted the main DPA office seeking conflict counsel. Due to Judge Costello having a docket, I don't think anyone else from the DPA was available today. In fact, I'm covering some of their cases. So
What are you telling me?
well, Judge,
That he needs another lawyer and y'all hadn't lined him up yet?
Correct.
Okay. What is he charged with?
Convicted felon in possession of a firearm.
Okay. Well, I'm going to set it for a conference day on January 12th, and I want a specific order directed to the Office of Public Advocacy to provide him with an attorney in time for them to go over and meet with Mr. Turner and prepare for that negotiation. I want him to talk to him before he gets to negotiation. His next court date will be January 18th.
Yes, Your Honor.
Okay, thank you very much, Mr. Turner.
what about the bond? I'm on 25,000 cash on me. I've been locked up now for about 6 months on this charge, stopping the guy from shooting me.
Yeah, well,
I mean,
I'm trying to get you a lawyer lined up. You fired your other lawyer. I wasn't aware of that until today. What are the circumstances?
Evidently, he was in a dispute with two other people, and he was arrested because he had a firearm on his possession. The other two people didn't want to prosecute him, but he was arrested because he was a felon in possession of the firearm.
Well, that's not true, Your Honor.
I'm just telling you what the police report said. That's all I'm telling you.
The police then just tell you, I've been shot and everything else over my property. I've even been drugged and gang raped and poisoned, and I'm one locked up. Now this is a kangaroo court. Now I'm not being railroaded by a small court, and now they're trying to do it here. I'm not saying you are, Your Honor.
That's good that you didn't say that.
I mean,
That's good.
you're twice.
I wasn't aware that you didn't have. But here's the thing about it is I'm going to try to get an attorney appointed for you immediately to come over and talk to you. And then because you've been there as long as you have, and out of consideration the fact that you weren't appointed somebody as quickly as I'd like, I will have a special hearing about this as soon as we can get somebody to talk to you. I don't want you to say anything else that might incriminate you. You understand what I'm saying? But I understand your frustration. So we'll have somebody over there post, okay?
And even medical attention about the bullets, I'm still packing where I've been shot. And
they'll come over and talk to you and bring anything to my attention, okay? So you're on my radar now, Mr. Turner, okay? Okay, thank you very much. Sonny Voorhees. Commonwealth of Kentucky versus Sonny Voorhees, 22 CR 0074. Are you Sonny Voorhees?
Yes, sir.
We're here on a probation revocation, Mr. Stockton.
I had the officers in this case subpoenaed, ready to testify and proceed in this case. And Mr. Bell says that he's got about, I don't want to mischaracterize what he's told me, 20 or 30 phone calls between Mr. Voorhees and the co-defendant in Barron County where he had this gun in this hotel room, where there was a gun in the hotel room. And he says that there's proof showing that it was her gun. Mr. Voorhees didn't know about it. I've not seen that yet, but that's what he's telling me. So I was waiting for him to get that evidence to me before we have a hearing.
Judge, we are in the process of putting that together for Mr. Stockton and the Commonwealth Attorney in Barron County, Ms. Cooper. She's agreed that if it is what I say that I have, which
what somebody else is claiming the gun,
basically
the gun, the drugs, and the truck that he was alleged to have stolen was returned to the co-defendant, was not even stolen. So I believe, Judge, we can completely exonerate him of these charges. I strongly believe that, and I've never stated that.
You can be exonerated if somebody else is willing to plead guilty to all the crimes involved.
Or if they make some admissions that would be admissible in court, that I believe 12 people.
So we'll schedule this for January the 18th then.
I'll have it done, but then thank you, Judge.
Okay.
You have a good day.
Too late. Where were you early when I really needed you? Tommy Webb. Tommy Webb. Commonwealth versus Tommy Webb, 23 CR 0047. Are you Tommy Webb? So here on 19 CR 0073 for a pretrial diversion revocation. What does the Commonwealth have to say in the case of Commonwealth versus Tommy Webb?
He does too. Mr. Webb's ready to enter a plea on 23 CR 47. If not, we need a trial date. Okay, he's ready to go. Okay.
You got a felony plea?
Yes, Your Honor.
Mr. Webb, I have just recently been informed that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person named in indictment number 23 CR 0047 and previously entered a pretrial diversion on 19 CR 0073? Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you?
Yeah.
Do you feel like you're fully informed about your case?
Yeah.
You understand you do not have to enter a guilty plea today. You have certain rights under the United States Kentucky Constitution, and before I can accept the plea of guilty, I need to know that you fully understand your rights. You have the right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court. If you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charge against you. Understand that by entering a guilty plea today, you give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept the recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report and from probation pro. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Now listen very carefully, Mr. Stockton. What is the Commonwealth's recommendation?
Your Honor, Mr. Webb will plead guilty to escape second degree, receive a sentence of 1 year. He'll plead guilty to possession of controlled substance, receive a sentence of 1 year. They shall run concurrently for a total of 1 year to serve. The 1 year sentence shall run consecutively with Monroe indictment number 19 CR 73, and he agrees to stipulate revocation. In that case, he'll pay court costs at the discretion of the court.
What's the total term with that year in consecutive? 4 years,
Does
okay.
this need to be?
Is that your understanding of the Commonwealth's recommendation, sir? Are you pleading guilty because you did commit the act charged in the new indictment and did violate your pretrial diversion?
Yeah.
Okay, I will schedule a, you understand with the, after entering this plea, if you have any convictions in the future, the range of penalty could be enhanced in those under persistent felony offender law. You understand that? If you have felonies in the future, in other words, if you have another felony, you could have a harsher term because you pled guilty to this felony. You understand that? Okay. Is that your signature on the docket there?
Yeah.
Okay. I will accept the plea and schedule a sentencing for January 18th. Dakota Williams. Dakota Williams. Are you Dakota Williams? 2 CR 0018. Are you Dakota Williams? Okay, you were born in 2003. Last 4 digits of your social security, 4744.
4741.
4741. Okay, it's wrong on the docket here. Thank you for the correction. This is a motion for shock probation.
Yes, Your Honor.
Did you get that different social security number over there, probation pro? It said
That was my mistake.
it was our typo. Take note. Megan made a mistake. Go ahead.
Judge, this is our motion, and just reminding the court a little bit. Dakota was here before the court a few months ago on when he was expelled for drug court because of a relationship with Miss Russell. Okay, Miss Russell was sentenced to probation. You had informed Mr. Williams and myself to bring this back before the court when he was.
How does the Commonwealth feel about this?
Well, the problem with Mr. Williams is.
He'll come around here where he can hear you.
Problem with Mr. Williams' case, which is distinguished from Miss Russell, is not only did he violate the participation agreement, he had he had a test for THC in November, tested positive for meth. November of 22, 1, 2, 3, 4, 5, 6, 7 times between November 5th of 22 and September 14th of 23. And then he missed drug testing on September 7th of 23 and 9/11 of 23. And when he was revoked, he wasn't maintaining employment or going to his self-help meetings. So I think there was adequate
Other
basis
than that was.
for his revocation, other than what he finally got on.
And again, Judge, none of that was mentioned. I don't even think those sanctions were even listed during the.
Okay, well, let's just reschedule another hearing and give him an opportunity to defend those if he doesn't want to. Want to do that? I think it would only be fair if I can't unhear that. You know what I'm saying?
What was put on, I have to go back and look at the tape and see what was put on during the hearing.
What was his underlying charge?
Burglary theft. He had 3 different cases. 10 years, and he served some time, and then he went into drug as part of his plea.
And Judge, just to note for the record, Dakota has a 5-month-old at University of Louisville, and the NICU has been there since he was born. Dakota's not yet got to see the boy. And I know that's because of choices he's made.
I will tell you what I'll do. You either work something with the Commonwealth, or if you want a hearing on all these things to get and allow you to put testimony on considering extenuating circumstances and what's changed since all these violations. Just seems like he was not compliant at all. Is my problem. Just is not compliant at all. So we'll allow you to schedule that if you'd like to on the 18th. Okay.
Yes, Your Honor.
I'm not going to rule against Dakota today based upon that. Okay,
Yes, Your
now
Honor.
let's go back. Do we have Orlando Shirley there now?
Yes.
Commonwealth versus Orlando Shirley, 21 CR 0096. You are Orlando Shirley. Okay, and you were born in 1973. And last 4 digits of your social security number is 0944, Mr. Shirley. Okay, this is a motion for shock probation. What does it come up? What do you have to say?
Judge, with Mr. Shirley's case, we're actually asking for him to be shocked into rehabilitation. He has indicated that he has a substance abuse problem, wants to get that under control.
What's the story on Mr. Shirley?
Your Honor, he has got a 5-year sentence.
You want to come around?
He's got a 5-year sentence on 2 different possession cases. He's got 7 months and 10 days into his credit. He likes 3 years and 5 days, but the good news is for him, he's parole eligible in February of next year. So I would ask the court to at least pass and see if he makes parole or not.
Well, it would be to his advantage because the parole would just be for 3 years. That's what we said earlier versus 5 years. Mr. Shirley, the discussion here that's been had in the presence of your attorney and the Commonwealth thinks that it would be to your advantage to wait till you go up to parole and to see if you make parole in February, you'll be eligible. If you don't make parole, I'm going to hold this motion for shock probation in abeyance so you don't lose your motion. Follow what I'm saying? So we'll take to see if you make parole. If you don't, I'll reconsider this as far as a shock probation. So you filed and protected your time on it. Okay.
Thank you, Judge.
Thank you very much.
I'll be able to talk to you, Orlando.
All right. Okay, now we had Jason Smith. Did we do Jason Smith earlier?
No.
Jason Smith. Commonwealth versus Jason Smith. 20 CR 0078. Mr. Smith, were you born in 1982?
Yeah.
Last 4 digits of social security number 4232. Okay, we're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, I proceeded to revocation in the hearing, but he was just indicted today on a new possession charge. I don't know if he wants to set it and try to wrap all this up or not.
And say you've been indicted today, Mr. Smith, and what they're talking about doing is setting a negotiation date so you can wind all this stuff together and see what it would take to get you clear, okay?
All right.
They'll do that. They'll come and bring you over here on January the 12th. And then on January 18th, we'll see if we can wind all this up, okay?
All right.
Okay, thank you very much. Now, I guess that takes care of everything except for Jared Smith.
No, you skipped over Jason Pitcock.
Jason Pitcock. Okay, Jason Pitcock. What you got on Jason Pitcock? This Jason Pitcock, 23 CR 0030. Are you Jason Pitcock?
Yes, sir.
You born in 1982?
Yes, sir.
Last four digits, social security number 2853.
Yes, sir.
You represented by Mr. Garrett. What do we have here?
Your Honor, the Attorney General's office is prosecuting, is handling this case from an investigative standpoint. And they did a search warrant to Google, which they have a return on, but I've not been able to furnish that to Mr. Garrett yet. And as soon as I get that, and according to Mr. Garrett, he'll want a trial date. So I think in January, we need to set this case for trial.
When do you want a conference on the 12th, or
I don't think it's necessary.
you agree with that?
I would agree. If there's any change in position, I'll get the whole.
Okay, January 18th, there's some new information they have, Mr. Pitcock, evidently. They hadn't shared with your attorney, so to be fair to you, they're gonna give him time to digest that information. He'll be able to see you sometime soon. Your next court date scheduled for January the 18th.
Judge, Mr. Pitcock had asked that I ask the court for a bond reduction.
You need to talk to Commonwealth about that. I don't, unless you want to hear him.
We did hear it.
Yeah, so we can schedule one if you want to.
Okay.
Before the next rule day.
Give you the speedy trial on the 18th.
Okay, now we have one other sentencing. Your attorney will be over, Mr. Pitcock, explain exactly. Oh, we got to add on somebody else here. Stephen Bray, is Stephen Bray there?
Yes, Your Honor.
Commonwealth versus Stephen Bray, which is 23 CR 0031. Commonwealth versus Stephen Bray. Are you Stephen Bray?
Yes, sir.
What's your year of birth, Mr. Bray?
6/11/70.
That's four digits of your social security number.
0058.
Hey, have you seen the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced today?
There is not, Judge, but just for clarity, I will note on page 7 of the PSI, it notes that Mr. Bray did not receive his GED. Later on, goes on to state that he did. And then there's a error on his age. It has him listed as 52 and he's 53. But aside from that,
Please note that. On the PSI, please note that. Okay, upon a plea of guilty to strangulation, you shall receive a sentence of 7 years with balance prorated for 5 years. If the entry of the plea, defendant has served 90 days in jail. He shall remain in custody until sentencing and make up, that's today, and the morning of rehab at the Mark Center. Have you got him a bed date?
I do, Judge. Mr. Bray was at Mark before. He is permitted to come and begin his treatment where it was at. The only thing with the Mark Center is they do not provide transportation. Mr. Bray tells me his father can take him to rehabilitation.
I can be there today.
He's going to obtain anger management and provide proof of enrollment upon completion of probation and parole. What was the court cost involved in this? It will notify your attorney about court costs, and we'll give you 30 days after that final treatment to do it.
Thank you, Judge. I guess we just wanted to get the court's guidance on if the court's going to be inclined to let Mr. Bray's father
Is
take
it
him.
residential? Is it residential treatment he's going
It is,
into?
yes.
Why does he need transportation back and forth to residential?
From the jail to.
From the jail to the
Oh,
center.
I thought he was going to wait till he got out of jail before he did it.
He gets, well, he's set to get out today.
I'm going straight to it as soon as I'm released, sir.
There's no problem with his father transporting him over there then.
Thank you, Judge.
Okay.
Thank you.
Now I've got one other case is that I have there's a confidential portion of this next sentencing, and I'd like for Mr. Jared Smith to stay in for you to take the other prisoners back to their cells, please.
Your Honor, on the 11 o'clock, the show calls, we have a Tommy Webb. Do you want to see him now or us just keep him out here? and bring him in after you're done.
We'll go ahead, and see Mr. Webb now. Tommy Webb.
We have one, but Tommy will be here for confidential.
Tommy Webb. Well, you got some court costs, Joe, and I'm just gonna put that off. We'll bring it back up on March the 14th.
Thank you.
Hey.
You sure? Oh, and we have Orlando Shirley for show calls also.
March 14th. March 14th also.
14th also.
Thank you. Now, when the room is cleared, we'll bring Jared Smith back up.
All right, they're out, Your Honor.
Commonwealth of Kentucky versus Jared Smith. 3CR 0016. Mr. Smith, you previously identified yourself. Mr. Smith wished to enter a plea today, is that correct?
That's correct, Judge.
Mr. Smith, a motion been tendered said you wish to enter guilty plea, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? Is this free and voluntary?
Yeah.
Are you the same person that stands under indictment in Monroe Circuit Court in 23 CR 0016?
Yes, Your Honor.
Is your judgment impaired today in any way?
No, Your Honor.
Have you discussed these charges with your attorney? Are you satisfied with his advice? Have you reviewed the evidence Commonwealth has against you? You believe you've been fully informed about your case? Yeah, I need to take a quick break. I'll be right back with you. Okay. So. Okay, sir, we'll resume. Have you had plenty of time to discuss this matter with your attorney? Are you satisfied with his advice?
Yes, Your Honor.
The evidence Commonwealth has against you, believe that you're fully informed about your case?
Yes, Your Honor.
Y'all key in the mic. Sorry. Have you reviewed are you fully informed about the case?
My knowledge.
Okay, you have certain rights under the Kentucky United States Constitution. Before I can set the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. The right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendations, I will await a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea. What is the Commonwealth's recommendations? If you listen very carefully, sir.
Your Honor, upon a plea guilty to sexual abuse first degree, C felony, he'll receive a sentence of 10 years. Upon a plea of guilty to sexual abuse first degree, counts 7 and 8, he'll receive a sentence of 5 years on each count. Those are Class D felonies to run for a total of 5 years. Upon a plea of guilty to rape second, he'll receive a sentence of 10 years on the Class C felony. Upon a plea of guilty to sodomy first degree, counts 1 and 2, Class A felony, he'll receive a sentence of 20 years on each count to run concurrently for a total of 20 years. Upon a plea of guilty to sodomy first degree, counts 7 and 8, Class B felony, the defendant shall receive a sentence of 20 years on each count to run concurrently for a total of 20 years. All these counts shall run concurrently for a total of 20 years to serve. There are 85% parole eligibility. He'll receive credit for time served. Commonwealth opposes probation or shock probation.
You also have to be a sexual offender.
Yes, we'll have to
So we
enter-
probably can't sentence it do the sentencing on January 18th. So let's do it. Let's schedule sentencing. Is that what you understand you're entering a guilty plea to, sir?
Yes, Your Honor.
Okay. We'll go ahead and I'll accept the plea order pre-sentence investigation report to be done by probation and parole. You understand that after entering a plea, there will be certain restrictions as far as reporting that you'll have to make. And also any future convictions that you might have could be enhanced under persistent offender law. Now you have the document there. Okay, I have a signature on here. It purports to be your signature. Is that your signature there, sir?
Yes, Your Honor.
I'll accept the plea order, pre-sentence investigation report, and sexual offender report. We'll schedule you to come back on February the 15th for your sentencing. Thank you. Thank you very much. Now, Barron County, do you have anybody else that you need?
Not your.
Okay, thank you. Thank you for your help and Merry Christmas to everybody there at the jail. Okay.
Thank you. Merry Christmas to you all as well.
Bring the grand jury in, please. Okay, everybody else can be seated. Are you still the foreman of the grand jury?
Yes, sir.
If you present the document, if 9 or more of you agreed on your findings there, okay, you can be seated there. Looks like y'all been quite busy today. Okay, well, I'm signing a document. We will have these entered into the computer system as quickly as we can. Warrants or summons will be issued with appropriate bond to be set on there to assure the attendance of these individuals or the protection of the public if they're deemed to be dangerous. If they are in custody, as I said, there'll be a summons. Now, that concludes your work. Now, is this schedule be I'd heard some desire for many of you to serve another 6 months. Was that misreported to me? It's not correct. Yeah. Well, y'all, it took more than 9 of you agreed to that for sure. Well, thank you very much for your service. I know this is an unpleasant thing to do. It's interesting at first, but then you see the difficulties and struggles a lot of people are going through. And I think it gives you an appreciation for what needs to be done by law enforcement officers and other people involved in the misery that a lot of people are in. So thank you very much for your service. The good thing about it for you is that you get, how much is their check? How many times they've been here? 6 times. That's almost $100. And maybe, will they get it before Christmas? They're going to try to get it before Christmas. So, you know, that means that you can go to McDonald's 6 times over that or whatever. But thank you so much for your service. You're a crucial part of the process here. It can't happen without you. And I think you understand now why the founders of our Constitution provided this safeguard to make sure that no one person in a robe or no prosecutor in and of themselves could take someone before a court and the possibility of taking their freedom away. And that's an important protection if you think about it. So Merry Christmas to all of you and Happy New Year. You may be excused. That finishes for the show cause docket. Okay, now we'll do the show cause docket. Just have 100 people on it.
February 12th and 13th.
85. Commonwealth versus Daryl Anderson. Issue bench warrant, $25. Commonwealth versus Amanda Bland.
February 12th and 13th.
Issue bench warrant. She can take care of it with $635. Teresa Botts. Issue bench warrant, $125. Jacob Bowles. Issue bench warrant. He can purge himself with $860. Roger Boyd, $275. Issue bench warrant. He can free himself for $275. Jacqueline Braswell, $440. Issue bench warrant.
A lot of these have been taken off to my original docket, so I'm not sure if they paid on these people you're issuing.
Well, if they paid, you need to tell me when I call them. Okay?
So a lot of, I think.
Okay, I'm gonna pass all these till January. I don't have confidence that I don't want to issue warrants for anybody, but y'all have a mark who's paid?
You'll start over on
Okay, we're starting over. Commonwealth versus Daryl Anderson. Okay, has he paid anything? Issue bench warrant. Commonwealth versus Amanda Bland. Okay, how much did she pay? Okay, Teresa Botts.
When will she continue
to? January, when did you continue to?
I believe it was January the 18th.
January the 18th. Teresa Botts. Issue bench warrant. Jacob Bowles. I'll tell you what, let's just continue these until, continue all these to February the 15th. And then that'll give you time to have them ready if they paid anything by then. And send them another notice out if they hadn't paid, okay? Give them a little Christmas gift from the Monroe Circuit Court. Okay, that concludes the business of Monroe Circuit Court. Let's go off the record.
Hey, Your Honor.
Yeah, Mr. Howard there. What we got on him?
He was on the show cause.
You're on the show calls docket. I'm going to give you till January the 18th to make some payment, okay?
Yes, sir. I'm currently in rehab right now in case y'all.
Okay, okay, that'll be good. Thank you.
Yes, sir. Thank you.
Merry Christmas.
Merry Christmas to you too, sir. Happy New Year.
Yeah. Okay. How do I turn this off?
I'm working. So you need to say,
Here,
I need to be 20 times and you just can't come back.
Here, Ms. Hunley, I want you to take this. I might beat myself to death, this damn thing, if somebody doesn't pick it up.
Yeah, so far,
Fox versus Fox. Let's go back on the record.
Continue until January the 18th, please.
Gallup versus Gallup.
January 18th for review, please.
Hagan versus Hagan.
January 18th for review, please.
Heston versus Heston.
January 18th for review, please. That's gone.
Yeah, my arm's shorter, I think. Hudson versus Hudson.
January 18th for review, please.
Jimenez versus Jimenez. Did I get it right?
January the 18th. To the best of my knowledge, that's how you pronounce it.
Johnny Bell was here. He could help us.
Yes.
Keith versus Keith.
January 18th for review, please.
Brown versus Scott.
January 18th for review, please. So it's just.
Thurman versus Thurman.
January 18th for review.
Is that it?
That is it.
Okay, thank you so very much. Okay, the civil docket is running a little late here. U.S. National Bank versus Timothy Daniel.
William Rich on behalf of the plaintiff. It's a motion for in rem default judgment and order of sale. All parties have been actually or constructively served.
Give me the file. Is your order referring the matter to the master commissioner for sale?
Yes, and the $200 sale fee, I believe, has been paid, Judge. There should be an order referring to the master commissioner.
And okay, thank you very much.
Thanks, Judge. Appreciate it.
Turner versus Guffey.
Yes, Your Honor, this is my motion. I represent the petitioner. This is just our motion for the cabinet to calculate and collect on a temporary child support order.
Okay.
I think I've tendered, here's the order, but I e-filed it as well.
Thank you. Hawkins versus Hall. Are the parties here?
The parties are both here.
Why don't you bring them up here and let's recite it on the record here.
I have an order that Ms. Hall signed as having seen and agreed. Judge, a little background. Marquita Hall is the mother of these two children. Rusty is the half brother of the two children. They've been in his care, lived with him for the last 3 years until his father passed away. How long ago was that? July 11th. July 11th, who was the father of these two children. But even before he passed away, due to the declining health of their father, they lived with their half brother. He meets the requirements for a de facto custodian. And we're awarding joint custody to Rusty and the mother. That way, Mr. Hawkins can continue to make decisions.
Neither one of you have objection to that. You agree with that? Okay, that's good.
Thank you.
Thank you.
We recited the factual necessities to make the de facto custodian.
I see that.
And it was a verified petition for custody, so that's been approved.
Okay.
Thank you very much.
Thank you. JLB Advisors LLC versus Lisa Cleary and others.
Complaint, Your Honor. There has already been a sale of the property. However, a couple of parties were left off. This is for purposes really of dividing the money. So.
Who did you leave off? Wasn't one of your clients, was it?
No, it was Cavalry SPV and Portfolio Recovery Associates.
What kind of claim did they have?
They have judgment liens that were filed, and somehow between my title search and drafting of the complaint, they got left out.
Do you have the money? Okay, you want to look at the, are you familiar with?
Yes.
You're in concurrence with this? Okay, Mr. Bailiff, you retrieve that for me. Thank you so much. Okay.
Thank you.
Yeah. Brown versus Lawson, is it correct?
My case, Your Honor, I represent the petitioner. This is just our motion to adopt the recommendations of the Domestic Relations Commissioner.
Okay.
And I think I e-filed that order.
Okay,
Yeah.
we'll make sure it's entered then.
Okay, thank you.
Mid-South Capital Partners LP versus Travis Ray Norris Jr.
Judd Patterson from Mid-South. That's our motion for default summary and order of sale.
What kind of, is this a tax?
It is, Your Honor.
Okay.
He restricted his directory member. And he made me aware of this. Does he need to be in here?
Well, if he had something to say, we probably ought to wait. He's on the grand jury.
Okay.
If you don't mind, we'll send somebody down there and tell him that he can come back up here. It won't be long. The orientation.
Was it one of the parties or one of the attorneys?
I don't know. Wasn't the plaintiff. It'd be one of the defendants, right? Travis Ray Norris Jr. was on the grand jury, right? Okay. Pedigo Kelsey Elizabeth Caps Pedigo versus Jonathan Pedigo. Hello.
Me. I filed a motion. I was appointed friend of court in this case about 6 months ago. The court ordered them to pay me a fee. Each party was to pay me $350 and I was to tender an order. Mr. Pettigo paid me very quickly. Ms. Capps, not so much. I called, sent letters, tried to set up payments. She never paid anything. Mr. Pettigo then, I didn't submit the order because I was waiting for payment, so it was never entered. I think he now is having trouble getting the mom to follow the schedule that was agreed upon because there was no order. So I submitted the order by e-filing and would hope that the court would go ahead and sign it. So it is in place.
You
So
want to
he has-
show cause for her to be here next week?
And that's it. And I know she got the motion. She called my office Monday to ask if she could make a payment and not come today. I had said if she would pay half of what she owed, but she didn't call back. I got a message. She called my office about 30 minutes ago to ask about making a payment. So I'm not sure how you want to handle that. Normally I'm not one to chase down these fees, but Mr. Pettigo paid his part, so it's
Okay,
really
well,
not
go
fair.
ahead and sign it, and you prepare us to submit a show cause order why she should not appear here. 1 o'clock on January 18th, to show cause why she should not be held in contempt for failure to pay. Okay?
And you're going to go ahead and enter that order on
Reach
time
out.
sharing.
We will.
Thank you, Judge.
Yeah. Yeah, Mr. Norris, are you back in here? Okay, this is the, stand there, and this is the Mid-South Capital Partners. Evidently you had a tax lien, is that correct?
Yes, yes, Your
Not against me, it's against Roger and Judy Good, the one that owned the place before I did.
Yeah. Well, where are they at now?
They're both deceased now.
How old is this tax lien?
2010 bill, Your Honor. I believe, let's make sure.
It was like 90 something dollars, and then they contacted me wanting right at $4,000. I told them I didn't know it, that I wanted to go to court or something.
Well, I think that you need to lawyer up. You need to see one of these lawyers here in town, and let them review so you'll be satisfied. I don't know whether I've ever had one from that far back collected or not. 13 years ago.
But it's not uncommon, unfortunately, Your Honor. These were filed and it takes a while to get them moving. But these are the most uncomfortable for me when there's a situation where there's a seller and there's a subsequent buyer who doesn't know.
Especially $90, you want 4,000, that's a little rough too.
That's what I said. I offered them 500 just to get it out of the way, and they won't take it. They still won't. Instead, it's going to keep going up. So,
well, you need to have, once you lawyer up, we'll come back here on January 18th to give you an opportunity to do that. Okay, take a look at it. Thank you. You can submit your proposed judgment if you like. Did you electronically file it? Okay, I'll take a look at it. Okay, thank you. Yeah, absolutely. Yeah. Victoria Alexandra Paragon versus Flavin Michael Paragon.
Hello, Your Honor. We're here on. Yes, we're here on my motion to transfer physical custody immediately to Mr. Pergo. We have two affidavits filed, and Mr. Pergo could attest to those if needed. The first one talks about the Apple locating his iPad on a Fountain Run Road and not getting the visits. And the second one talks about a letter we just received a copy of that Mrs. Pergo had, or Ms. Collins had filed in France. And it is very concerning. There's half a dozen spots that I could quickly.
Yeah, I'm going to pass this to the end of the docket. It won't be too many. Okay. I can see this is going to be lengthy. So y'all have to see there. Independent Capital Holding LLC versus Linda Driver Turner.
Judge Patterson for Independent Capital Holdings, Your Honor. This is, again, our motion for default judgment, summary judgment, and order of sale.
Judge, I'm here on behalf of Jerry Driver, and he's one of the defendants. I have no problem with their interim judgment and order of sale, but I do have a problem with how they've drafted it, making their tax liens superior to any other claim when they were purchased 2 and 3 years after my client's judgment lien.
Your Honor, KRS 134-420 makes.
Speak up so we can hear you.
I'm sorry, yes, sir. 134-420 makes all ad valorem tax liens superior to any other kind of lien or encumbrance. It doesn't matter when that encumbrance is placed on the property, ad valorem taxes are superior. And that law is clear.
What do you have to say to that, Mr. Meredith?
Clear. They purchased these tax liens knowing that my client had a $35,000 judgment lien against his property, and it doesn't put them ahead of my clients. They could only be in the same position as the taxing authority was, and the taxing authority's bills weren't due until 2.5 and 3.5 years later after I'd already perfected my lien. So I certainly question the validity of that. I have no problem with the property being sold. I just have a problem with them trying to say that they're superior to anybody else's claim.
How much is your judgment lien for?
My judgment lien is in excess of $35,880 plus interest.
It wouldn't make much difference if the county's got a 2020 bill and the property gets sold. The county's 2020 bill is going to get paid before his judgment lien. And any bill bought previous to that, the third party purchaser stands in the shoes of the county. And so the timing of it doesn't matter. The priority of the bill is the same.
Well, Mr. Meredith, if you want to, I'm gonna let you brief that. You give me a real brief and serve it on opposing counsel, and you can reply to it. I'll take it under advisement. Okay.
That'd be great.
Thank you, Judge.
Okay. Mid-South Capital Partners versus unknown heirs of Benny somebody.
Yeah, they give this one more shot, Your Honor. I'm 0 for 2. This again, another motion.
You're winning. It's just a matter of when.
That's right. Another motion for default summary and order still, Your Honor.
Okay. We'll submit that. We'll take a look at.
Should all be in the file.
Your judgment. Okay, that'll be fine.
That's all I have. Maybe excuse.
Yeah, absolutely. Okay, let's go back to the case from France.
Thank you, Judge. I appreciate Ms. Atkins being able to make it today. We have 2 affidavits with which Mr.
Hey,
Perigo.
Bonnie, wait just a second. Just tell me what you want up front, so I won't have to.
Okay, we've tendered an amended supplemental order, and it transfers custody to Mr. Perigo immediately.
If I've made a ruling on this case yet.
This is the first thing we had before us. We've only had the EPO.
Yeah. Well, this is I was just reminding my staff, Laurie, that all the other hearings that we had were on the EPO, and this is the first time we're here on this.
Yes, sure.
What do you have to say?
I object to hearing the motion at this time. Counsel's aware that motions for custody have to be supported by multiple affidavits, and I don't think that requirement is met by having her client sign 2. The clear indication of the statute is that it should be affidavits from multiple people, not Mr. Perigo signing twice.
Your client just signed 2 affidavits rather than get some other party?
No, this is an enforcement of the French order under UCC JEA. And under UCC JEA, no custody determination or best interest analysis is permitted or required. That's part of our briefs that have been submitted. The urgency has come about because of what we've found in the letter from.
Well, wait just a second. Okay, now go ahead.
I was going to say, we already have a date set to determine UCC JEA enforcement. That is not what counsel tendered today. She filed a motion for immediate custody. You have already scheduled a review for UCC JEA enforcement for the 27th. Our final brief is due tomorrow. We have not even completed the agreed upon time for briefing on the issue.
Okay, what do you have to say to that, Ms. Bonnie?
Okay, it is Miss Atkins tendered her brief. I tendered mine, and technically, yes, she's entitled to 5 days to respond. However, any challenge to the authenticity of the French order or the substantial conformity with UCCJEA would have been incumbent for her to have put in her initial brief. I filed a responsive brief. Now, what's happened is, and I understand that the registration is a separate function. It's permissive, it's not required, and it's shown to be on the index as going to be tendered to the court on December 27th.
You've lost me.
Okay.
Okay.
That's not good.
Here's the thing about it.
Yeah.
She wants me to wait till after I have the hearing on this stuff, on the issue, on whether it's subject to the Uniform and Act. And so you want a judgment of immediate transfer of the
physical custody, yes, which is permitted.
Yeah.
It's permitted. It's after
it's permitted, but it's not required, is it?
It's not required till after conformity.
Then I'm not going to do it. I'm going to wait till we have the full hearing and everybody gets their say. Your client, both sides are going to give me a full hearing that I'm going to hear and educate me about the act, and then I will rule accordingly.
Your Honor, we always have briefs tendered on that, but the 27th, I understand, is a review without counsel.
That's the review you had set. It's the final deadline for us to file any objections. Again, she's acknowledged I am entitled to the 5 more days for the final brief, and the court has given us till the 27th to file objections. I'm only requesting.
You think you're entitled to a hearing after that?
No, Your Honor.
Okay, she's not asking for hearing. She's just waiting for the 27th, and everything will be submitted then, and I'll reach a decision.
Your Honor, understand that the counsel will not be present on the 27th. Is that correct?
I don't guess anybody else will be present. It'll be my staff lawyer will be looking at all the things that have been filed, and nobody will be able to.
Your Honor, could we get some understanding about the visits that are not being kept and in violation of these court's orders? And can we
tell me about it? I can't tell me about it.
Okay. Mr. Perigo could attest to what's in his
you just tell me about it real shortly. Wait.
Okay.
When I asked you what time it is, I don't want you to tell me how to make a clock. Okay, just tell me what visitation that I've ordered that he's not getting.
Okay. There's been about 10 visits. The first one complied with the court order. None of them have since. Mrs. Perigo apparently is under the belief that the children are permitted to refuse to visit. And the children, he's seen his daughter twice. He's seen his son 4 times. And some of those times, his son left and was going to come back and then didn't. And other times, no one connected. And other times after that, the camera was turned on, pointed to a field, and no one showed up.
Yeah, wait a second. What's the deal with the visitation?
The initial order that you entered was that the children had to be made available. You specifically permitted the oldest child to sort of come and go. The order was visit every weekend, make the children available. The children have been made available. As counsel acknowledged, the children have participated in the visits as they chose, which was in compliance with your order. If there is further orders to be entered, we will of course comply.
They claim he hasn't received the visitation. What would that claim be predicated upon?
There was a few times where there was a technical difficulty very early on in the start of the visits. There's a 9-hour difference, and there was some problems with communication, getting the correct Zoom link to the parties. But it's my understanding that he has, and as they acknowledged, he's seen the children. They've participated in the visits.
No, the camera has been focused on a field. The children were not visible to him. And there was also evidence that they weren't even there to be called over.
Okay, let me tell you something. I'm not playing games about this. I will jail you if you don't let this man talk to his children like I ordered you to. I don't want any lame excuses and pointing the camera out somewhere else, or they don't feel like they don't want to. They aren't in control of this situation. He gets to visit them, and if I have one other disruption or complaint, I will jail you for contempt. Do you understand that? Let me hear verbal from you.
Yes, Your Honor.
Okay. Okay, we'll submit an order on that. Now, what about the holidays are coming up? How's the visitation schedule for the holidays?
There's none scheduled. It's just every Saturday from 1 o'clock to 1:30 Central Time.
Okay, well, what day is Christmas on this year?
I believe it's a Monday.
A Monday. Do you celebrate Christmas or not? Okay, does your client celebrate Christmas, Bonnie?
Yes.
Yes, Your Honor.
Okay, well, what I want to do on Christmas Day, I want to have an extra visitation on Christmas, and I don't know how the time works, but Santa comes over there before he comes over here. So I want y'all to, the two attorneys, to work out a special holiday visitation, which might help to ameliorate the problem, Bonnie, that you've had up to this point about not getting, we'll get an extra visitation here. And then I want you to be very carefully about exercising these others. I'm going to take a look at everything on the 27th and do the best we can to get an order that's appealable out on this thing as soon as we can, okay?
Your Honor, can his parents and family and their children's friends be on the call as well?
Absolutely.
That's fine with us, Your Honor.
Absolutely. And they can have.
That's good. We haven't been able to arrange that in the past.
Well, we just arranged it. I mean, the whole family, it's Christmas, and hopefully everybody will enter into this with the belief that there can be disagreements between parents, but grandparents and nieces and nephews and cousins need to get together this time of year and talk and be able to socialize and just see that everyone's okay. If nothing else, see that everybody's okay. Okay, well, I'll look forward to getting the rest of the briefs, and if by some reason there's some agreement in this case between now and then, I would always be prepared to sign an agreed order. Doesn't seem likely, but in any event, hope springs eternal. Thank y'all very much for your patience. And Ms. Bonnie, will you circulate that order that we decided today, and hopefully we'll be okay. Okay?
Yes, Your Honor, I'll have it by the end of the day.
Thank you very much.
Thank you, Your Honor.
Yeah, thank you.
Thank you, Your Honor.
Yeah. Allison, can we chat?
I probably will be back in the office today based on the time difference. I can call you tomorrow morning.
Okay, that'll be fine. We just need to set a time. Thank you.
Thank you.
Okay, is that it? That concludes the business of the Monroe Circuit Court. Okay, nobody else in line?